Divorce Television with Wally Marcus. Our guest today, adversary divorce with attorney James Stroud. Support for Divorce TV is made possible in part by funding from the Center for Divorce Mediation, 577-1202. Welcome again. My guest today is James Stroud, who is a well-known adversary divorce attorney and family law attorney in Tucson, and I'm very honored to have you as a guest today. We're going to be talking about adversary divorce, and we're going to be giving you a little bit more information about Jim later on in the show, and you'll see it if you want to reach him. But you'll also notice at the bottom of our screen is information on how you can reach us. If you have questions or you want to learn more about our future programs, feel free to contact us at that address. Jim, can you tell us a little bit about yourself?
Yeah, I'm a lawyer. I've been practicing in Pima County for 33 years. I'm a shareholder in the firm of Stompoli & Stroud, PC, which means professional corporation. I'm a certified specialist in family law. In fact, I was in the first group that was certified as family law specialists in the state of Arizona.
If you can later on, come back and tell us a little bit about the certification and what that means. I'd like to know more about that.
We'll come back to
that.
Yeah, and I do exclusively family law cases, and I'm in the Academy of Matrimonial Lawyers and listed in Best Lawyers in America, and I have a divorce practice that does not emphasize collaborative law and that kind of thing. I do traditional divorces, which you've chosen to call adversary. I don't think of them as adversary.
What would you call it?
Divorce.
Divorce? I don't know.
Traditional divorce.
This is a little bit like when they switched to digital watches and analog watches, and what do we call analog and what we call digital? It's I know, hard to distinguish.
Well, you know, one of the advocates of collaborative divorce at a legal education program recently said, well, I don't think of collaborative divorce as alternate dispute resolution. I think of going to trial and having a trial as alternative dispute resolution. And I agree with him that going to trial is a distant last place choice. I only tried one trial last year.
Very good.
The fact that we're calling it adversary does not mean that you're in court fighting about things. What it means is that you have the two sides who are negotiating, and the threat or the last-ditch possibility is that you might go to court, put on your evidence, make your brilliant argument, and have the judge make the decision. But in all kinds of divorce, you're trying to negotiate and trying to mediate.
That's good to know. I mean, thank you for appreciating it. I think a lot of people in our audience don't really understand or appreciate what the subtle differences are we sort of take for granted on this area. So I think it's a good point to make. Before I forget, let me tell people where they can reach you again. I know you gave it to them, but it's sometimes hard to reach. So on our screen now is attorney James Stroud's website and his telephone number. Hopefully I got it right. And that's where you can reach him, and we'll flash it on a few times during the show so you can catch it so if it goes off again.
Actually, you did in fact misspell my website.
Give us the correct one.
It's Stompoli, Stompoli. There's no R.
I'm sorry. That's one of my weaknesses. I have to always do that. I'm sorry to do that one, but we'll make sure we correct that as we go along.
Okay.
Your topic is adversary divorce. You started talking to us a little bit about what that means, but what it means. Can you tell us a little bit more?
Well, I mean, basically, the way a traditional or adversary divorce works is that the two sides begin by gathering information and exchanging information between them. There are formal ways that you can do that. Interrogatories, which are written questions answered in writing. Depositions, which is where you call the opposing party in and question them under oath. Requests for production, which is where you ask the other side to provide documents to you. There's also a thing called disclosure, which is like discovery, but you do it without being asked, because there are court rules telling you, here's the information you have to exchange. And then once both sides have the information they need, then they begin a process of negotiating and attempting to agree on the terms of the divorce. If it looks like they're not going to get that accomplished, then one side or the other files a request to have a trial date assigned to the case. Now, the fact that you have a trial date assigned does not necessarily mean that you're going to have a trial. In most cases, the impending trial date is simply kind of an incentive for people to get their stuff together and make a settlement, and then
So do you find that the threat of the trial ends up being a way of helping you resolve the case?
It is in some cases. I try to get right on top of my cases soon enough that it's very rare that I get to the point of having a trial date assigned.
I mean, we always hear the expression it's settled on the courthouse steps.
You hear that expression a lot, and there are many cases that are settled that way. I'm a judge pro tempore, which is a substitute judge. There are about 50 of us, and anytime there's a trial date assigned for a divorce case, what they do is 2 weeks before that, you have a settlement conference conducted by a judge pro tempore. The two lawyers and the two parties come in and meet with the judge pro tempore and try to settle. Nothing you say in that conference can be used against you in court. And we have a very good, I don't know the statistic, but I'm sure it's between half and 2/3 of the cases that haven't settled up to that point do get settled.
I was surprised that you said
conference.
that you'd already only tried one case, you said, in the last year. Why would some cases get tried and other cases not get tried?
Well, the case that I tried last year, and I've had years where I've tried more than one case, mind you, but this was a case in which the parties had signed a premarital agreement years ago in another state. And if it was upheld, there was going to be no community property. If it wasn't upheld, there was going to be community property. And the lawyers, I mean, it's kind of a yes or no question. It's hard to negotiate that question. Normally, when you make a settlement, everybody gives a little. But in that instance, it was either enforceable or not. So we went to trial. I won. The judge ruled that it was not enforceable. And the case settled literally within 20 minutes after we got the ruling. Because we all knew that if the property was community, here was how we were going to divide it up.
What other kinds of cases have you had over the years that are sort of, or trial? Or can you tell, I mean, in advance sometimes if it's going to be like a case you think is going to try? Or...
Oh, yeah. Oh, yeah. I mean, usually if a case goes to trial, a divorce case, usually if it goes to trial, it means that either one lawyer is not giving good advice or one party is getting good advice and not accepting it. There's really no reason in most divorce cases that you shouldn't be able to make a settlement. Occasionally you'll come upon a novel issue that there's no law on yet, that's never been confronted by the courts of this state and wasn't taken into account by the legislature when they wrote the law, and you end up, you know, somebody has to go to trial in that case and kind of make some new law. But that's pretty rare.
Do you find in the adversary cases that your clients are angry or not angry, or... I've always sort of been also, I mean, where I was sort of going with that a little bit is I'm always sort of fascinated why, since we do have collaborative, we have litigated or trial cases or divorce cases, as you phrase them, and we have mediation, and why people choose or what's appropriate for each of those couples.
Well, it depends partly on how complex the case is, what the issues are. It depends also on the personality of the parties. I mean, I've kind of reached the point in my career at which I'm not going to take a case of someone who comes in and just seems angrier than anything, and that they have a lot of stuff that has no legal significance, but a lot of emotional stuff that they want to vent in a courtroom.
What do you do those? I mean, it seems to me in my practice, I see a lot of people, you know, over the years and that are angry, and it seems to be a byproduct of divorce.
I mean, one thing you do is you refer them out to therapists, and you help them understand that a court case is not an occasion to work out your anger. That there is no part of the divorce law system that gives you the option of going in and telling your nasty story to the judge. But as far as what I personally do is, if I think I'm getting nowhere on explaining that to the client, I don't take their case. I guess somebody takes it eventually. I mean, they end up with a lawyer. But so in terms of you mentioned mediation and collaborative, I send lots of parties to mediate, a whole lot. If you're mediating, it still is a good idea to have at least consulted with a lawyer to find out what your rights are. It's a good idea after